So one of the main ones I'm going to look at, though, are anti-bribery and anti-corruption due diligence. And most people would accept that the ability to carry out anti-bribery and anti-corruption due diligence is very important. People regard it as essential to the proper functioning of markets and democratic societies. And that generally involves holding companies responsible for the acts of themselves, their agents, and their intermediaries. And because they can be responsible for the acts of their agents and their intermediaries, they need to carry out appropriate due diligence and checks on their entire supply chain. And it's basically to avoid potential criminal liability. So there's a variety of conventions in relation to the matter. There's an OECD convention, there's an EU convention, there's a Council of Europe criminal law convention on corruption. And even if a company is clever enough to have contractually prohibited any of its intermediaries or agents from bribing any third parties, that won't of itself make them innocent of that crime, and it can still be held liable if that transpires to be the case. There's also a clear public interest in carrying out anti-bribery due diligence. There's been a lot of studies in relation to the economic cost of bribes, corruption in government, and the increasing cost of procurement if you don't resolve that potential issue. And then there's also a clear interaction with data protection law, because in order to carry out these checks, by necessity, you will be processing personal data on individuals. And if it comes to criminal data, you're obviously processing a category of, I call it in general terms, very sensitive data, but we'll see that Article 10 applies to it and it's actually prohibited. So what's the issue then? Well, the issue is that if you're processing data for the purposes of carrying out an anti-bribery or anti-corruption due diligence check, and it transpires that it's criminal data, it's prohibited by Article 10, unless it's authorised by union or member state, or otherwise under the controller of official authority. The solution, which we describe to clients, is clearly, well, make sure that there's EU or member state law that facilitates that. The problem is that many member states don't have these laws. The other problem is the potential divergence of approach. So one member state might apply a particular facilitation for processing criminal data in one context that another member state doesn't allow. So patchwork solutions very often don't work. They result in different approaches between member states, and they may also create an unnecessary compliance burden, particularly for people dealing on a multi-state basis, to find out that they have a different obligation in Ireland vis-à-vis the UK, vis-à-vis France, vis-à-vis Germany, vis-à-vis Austria. That's very difficult. It's particularly difficult for service providers outside of the EU who are processing data relating to people within the EU in the context of carrying out anti-bribery and anti-corruption due diligence, because they're likely to have to comply with the laws of each of the different member states, or to comply with the prohibitions of each of those member states. That has a potential chilling effect on cross-border trade. The question is whether it's an unintended consequence, and I think the argument is that it wasn't actually an unintended consequence, because whilst a lot of us didn't spot it at the time, Article 10 is very like Article 8(5) of the 1995 directive. I don't know whether we just all ignored it, or maybe there wasn't as much anti-bribery and anti-corruption due diligence done post-95, who knows. But in terms of some of the solutions, and jumping past the Irish one for the time being, the UK came up with a solution in their Data Protection Act, Part 2, Schedule 1, Paragraph 11, where they do facilitate anti-bribery and anti-corruption due diligence as long as you have appropriate safeguards. Ireland has done something relatively similar. The Data Protection Bill that came out last February didn't look likely to facilitate anti-bribery and anti-corruption due diligence. There was a late amendment following a meeting that we had with the Data Protection Commission and then the Irish Department of Justice. And we're very grateful to both of those organisations in terms of facilitating, listening to us and understanding that there was an issue. You still can't carry out those checks in Ireland in light of GDPR, but the Irish Data Protection Act does now envisage that there will be regulations which will allow such processing. But I would stress it's processing subject to appropriate protections. So it's not going to be a free for all in terms of the processing of this data. It still has to be relevant, it still has to be proportionate, it still has to have appropriate checks and balances, likely a data protection impact assessment as well. Germany and Austria, one of our clients also needed to do checks in those countries, and it doesn't look like it's facilitated there as yet. They're also checking in the Netherlands and other places, and there's just a common theme is that there's only very few countries that will facilitate this processing right now. I don't think it's an unintended consequence. I just think it's what the policymakers intended to happen, because they understand that criminal data the processing of criminal data is very invasive. But you need a solution then outside of that. You need local laws or pan-European law, and I'm not sure that was properly envisaged by people other than data protection policymakers. The best solution is going to be an EU-wide solution. The problem with that is it could take a long time. So in terms of the quick and dirty fix, it's probably going to be the laws of member states, albeit that there is potential for divergence.